The Orissa High Court has upheld divorce for a man, stating a husband is entitled to peace and emotional relief that can only be found in dissolution of this broken bond. This is a case where parties had been living separately since 2009, 45 FIRs had been filed by the wife, and in the end, even after cruelty by wife was established, the Orissa High Court ordered husband to pay alimony. Let's understand the facts and background in this matter first. Parties got married at Cuttack in May 2003. Post-marriage, the couple started residing at their matrimonial home in Haripur and later lived at different locations such as Bhubaneswar, Bangalore, USA, Japan, etc. But the marriage was soon strained when the wife allegedly asked her husband to sever all ties with his parents, demanded financial control by insisting on being the sole nominee in his insurance policies, and frequently engaged in quarrels. After facing continuous marital discord, in the year 2009, the husband filed for divorce under Section 13 of the Hindu Marriage Act, seeking dissolution of marriage on grounds of cruelty. Let's understand what were the allegations by the husband. According to the husband, his wife's conduct had made it impossible for him to continue the marriage. His primary grievances included constant quarrels, financial control, and the forced eviction of his elderly parents from their home by the wife and local goons. The counsel for the husband highlighted that the wife systematically harassed him and his family by filing multiple false cases, including over 45 FIRs against him and his family members. It was also stated that the husband, who resided abroad for employment, had been forced to defend himself in multiple jurisdictions and has been subjected to continuous harassment at the hands of his wife. The counsel further stated that the repeated abuse of legal processes was solely intended to create mental distress for the husband and to prevent him from leading a peaceful life. Now, what was the defense by the wife? Contesting this divorce petition, the wife, on the other hand, filed a case under Section 9 of the Hindu Marriage Act, asking for restitution of conjugal rights. In her defense, she denied all the allegations made by her husband and claimed that he was the one who abandoned her without justifiable cause. The wife further added that she had always been willing to reconcile and resume cohabitation, but the respondent refused to continue the marriage under the influence of his parents. She even contended that her marital rights had been unfairly denied. Now, what was the Cuttack Family Court's decision in this matter? In August 2023, the learned Cuttack Family Court judge delivered a consolidated judgment addressing both the divorce as well as the restitution of conjugal rights cases together. After noting evidences on record, the court concluded that the cruelty by wife had been established indeed, and thus it granted divorce to the husband under Section 13 of the Hindu Marriage Act. The family court also observed that the wife's persistent behavior of quarreling, financial control, and acts of intimidation against the parents of the husband, when she, along with local goons, forcibly ousted the respondent's elderly parents, this act was deemed to be a significant act of cruelty. Consequently, the marriage was legally dissolved, and the court also dismissed the appellant's prayer for restitution of conjugal rights. Now, most important, despite the family court saying clearly that cruelty by wife had been established, it still went ahead and awarded Rs 63 lakh as permanent alimony to the wife. However, not pleased with the said order, the wife appealed against this divorce decree and also the quantum of alimony in the High Court. Let's understand what were the contentions of wife while challenging this order. The counsel appearing on behalf of the wife submitted that the family court erred in its judgment, which was legally unsustainable and also liable to be set aside. The counsel contended that the dispute arose not from any cruelty inflicted by her, but due to the husband's deliberate desertion and abandonment of the marital relationship. The wife further argued that her bona fide intention to resume cohabitation was clearly demonstrated by filing RCR. She also stated that the family court only relied on the testimonies by the husband's family. Interestingly, with regards to the multiple FIRs and cases in the process, the wife claimed that this was a legitimate exercise of her legal rights and cannot be construed as cruelty or harassment. Now let's understand finally what were the observations and judgment by the Orissa High Court. At the outset, the division bench of Justice Chitranjan Das and Justice B.P. Rutre observed, since the parties had remained estranged for an extended period and the respondent having clearly refused to cohabit due to emotional distress, the court found no jurisdiction to delay the proceedings further. With regards to the wife justifying her legal right to file 45 FIRs, the High Court remarked, The frequency and nature of these cases go beyond a reasonable exercise of legal rights and instead demonstrate a calculated effort to exert pressure and inflict mental agony upon the respondent. Therefore, the contention that multiple cases alone cannot amount to mental cruelty fails when reviewed against the sheer extent of litigation initiated by the appellant wife and the prolonged harassment faced by the respondent husband and his family. Amongst multiple other statements, the High Court noted that the parents of the husband had given their testimony on oath, which stated the appellant from the very early days of the marriage had been abusive towards the family, both verbally and physically. In their sworn testimonies, they depose that soon after the marriage, the appellant wife hurled abusive words at them, consistently referring to them as bastard, choto loco, and bhikhari. The appellant even assaulted the respondent husband with a loha khadika, which is also an iron pot. The High Court then noted another incident that had taken place in November 2009, when the wife had returned to her husband's parents' house with her sister, and despite being welcomed by them, she allegedly began verbally abusing and physically assaulting them with fists and kicks, demanding to know her husband's whereabouts. The matters escalated so much at that point in time that the elderly parents of the husband were locked out of the house, forcing them to spend the night at a mutt and later seek shelter at their daughter's house. To this, the High Court said, these allegations were not made in isolation. The testimonies of the neighbors and independent witnesses corroborated these events, providing independent evidence of the appellant's violent and threatening behavior. The High Court also said, repeated threats to commit suicide or worse, to harm the spouse and the family members transcend mere emotional outbursts, and they represent a gross misuse of emotional vulnerability and a blatant form of psychological warfare. Dismissing the wife's appeal, the Orissa High Court concluded, the law cannot compel a person to endure a marriage that has become a source of suffering and torment, and the respondent is entitled to the peace and emotional relief that can only be found in the dissolution of this broken bond. Now, lastly, for the main information that all of you are largely interested in, the alimony part. Despite cruelty by the wife being proven, the High Court upheld the alimony awarded by the trial court. To this, the bench stated, marriage, even when dissolved, carries with it certain obligations that cannot be overlooked, particularly in cases where one party may face financial hardship post-separation. Taking into consideration the income, assets, and liabilities disclosed by both parties, as well as their educational qualifications and social backgrounds, this court too deems it necessary to fix the permanent alimony. Consequently, the permanent alimony of Rs 63 lakh awarded by the learned judge Family Court Cuttack is not to be interfered with. This amount seeks to strike a balance between providing the appellant with reasonable financial security and ensuring that the respondent is not unduly burdened, thereby upholding the principles of fairness and equity in matrimonial disputes. Now, what does Voice for Men India take in this matter? These cases make us wonder whether the husband actually got any justice or mere freedom by himself paying the money. Rs 63 lakh may just sound as a lump sum payable right now, but can anyone ever quantify the turbulent time he spent from 2009 to 2025, possibly losing his best youthful years, fighting false and frivolous cases by wife? Such financial rewards, despite husband being eligible for divorce, only encourages women to approach police, courts, satisfy their egos, and then have the last laugh. Keep following us on our social media handles, that is X, Instagram, Facebook, and Telegram. The ID is @VoiceForMenIn. If you're active on LinkedIn, you can follow our handle, Voice for Men India. You can also read several other articles and judgments on our website, voiceformenindia.com. If you find value in our videos, do consider giving us a like and sharing the same ahead to spread awareness. Lastly, do hit that bell icon and subscribe to YouTube channel Voice for Men India for regular updates. That's it from me as of now. Thank you very much for watching. Namaste. Jai Hind.